you, Dean Broderick, and thank you, Eva. I know you've put so much work into planning this event, and we really appreciate it. Hello, everyone. Thank you for attending. I'd like to extend a special thank you to Professor Terzano, whose death penalty class, as well as his mentorship and guidance, really helped me be here today in writing this paper. Is the feedback not good? Are we okay? Okay, great. My first year of law school was unique. Like many of you, I contributed to keeping the highlighter industry in business. I noticed my eyesight starting to fail, and I discovered the miracle of 5-hour energy. After that typical grueling first semester, I spent the holidays at home in Colorado with my family, and I returned the weekend before classes started. Here's where my experience starts to veer off course a little. On that weekend, I received a call from my cousin, and what she said to me stopped me in my tracks. She said, "Kristen, I'm not sure if you've been watching the news today, but your Aunt Pam was shot, and she's in critical condition in a hospital in Tucson right now." Now, my Aunt Pam, for the prior 4 years, had served as Congresswoman Gabrielle Giffords' Community Outreach Director, and she happened to be standing next to Gabby Giffords that day when a young man named Jared Lee Loeffner walked up to a crowd outside of a Safeway and opened fire, killing 6 and injuring 13, one of which was my aunt. As you may know, Gabby Giffords has made an incredible, remarkable recovery, despite being shot through the left side of her brain. My aunt similarly has made a very fortunate recovery. She was shot twice, once in the wrist and once in the chest. The chest bullet traveled down, lodged in her hip, and somehow it didn't hit any vital organs. As I was taking Professor Terzano's death penalty class, Loeffner was being considered for the death penalty. His sentencing, which had a direct influence on my life and my family, significantly impacted the way that I thought about the topic and the way that I researched and wrote this paper. Last week, Mr. Loeffner was sentenced to 7 consecutive life sentences with no parole, but not the death penalty. Now, what separates Mr. Loeffner from so many others who have served or are serving time in prison is the evidence implicating them. In Mr. Loeffner's case, he was immediately detained, wrestled to the ground, gun in hand, and later arrested. However, too often, suspects are convicted chiefly based on very fallible eyewitness identification evidence. I personally, as well as my aunt, hoped that Mr. Loeffner would not be sentenced to death. But regardless of any of our opinions on the death penalty, it's an incredibly complex matter, made all the more complex by cases, unlike Mr. Loeffner's, where the evidence is not nearly as obvious. My article focuses on the leading factor in wrongful convictions, which is eyewitness identification. In fact, 75% of wrongful convictions that are overturned by later DNA testing involve eyewitness misidentifications. Perhaps one of the most troubling consequences of inaccurate eyewitness identification is a significant setback to investigations, often beginning at the very early stages and permeating the entire outcome of the investigation. Too often, critical time is wasted while police are sidetracked and resources are devoted toward building a case against an innocent person. The Innocence Project reports that despite solid and growing proof of the inaccuracy of traditional eyewitness identification procedures and the availability of simple measures to reform them, traditional eyewitness identifications remain among the most commonly used and compelling evidence brought against criminal defendants. It's true, we're all familiar with that dramatic moment in the courtroom where the prosecution's witness points across to the defense table and says, "That's him. That's the one. He did it." We all know that Robert would never hurt a fly, so we're not too worried that I just implicated him.
But whoever's beside the defense attorney is the one.
Right. There's extensive scientific research about the psychological and social influences of human functioning and how those influences have led to many forms of eyewitness error. My article discusses these different types of influences, which include memory, unconscious transfer, misinformation, including suggestibility and misattribution, cognitive bias, outside influences, and relevant judgment theory. These influences have been widely documented and studied, based on psychological theory regarding human memory and social influence, as well as empirical findings from eyewitness experience. Unfortunately, despite the growing awareness that eyewitness misidentification significantly contribute to faulty convictions, many states, including Colorado, have failed to implement comprehensive procedural safeguards to address this issue, especially in relation to constructing photo spreads and lineups. My article aims to discuss these issues with eyewitness identification and concludes with a model for the Colorado legislator, although these types of procedural safeguards can and should be applied to any state legislator. Such procedural safeguards include culprit present versus culprit absent lineups, where neither the administrator nor the witness knows whether the culprit actually is present or absent. And that goes hand in hand with double-blind administration, so that there's no chance that the administrator, either purposefully or not, somehow indicates to the witness who the culprit may be. Further, there should be an instruction that regardless of whether the witness identifies someone, the police will continue to investigate the matter, and that it will not be closed based on their identification of one individual that day. There should also be sequential presentation. Instead of allowing a witness to look at all people in a lineup or a photo spread at the same time, they should be looking at them one by one so that they're able to evaluate them based on their memory of the culprit rather than relatively compared to everybody else in the lineup. Known innocent fillers should closely resemble the suspect. There should be at least 4 or 5 of them, and they should not stand out unduly among the rest of the lineup. And finally, the entire procedure should be very well documented, and the witness should be interviewed afterwards to see how confident they are in their identification and their feedback on the actual procedure. When these types of procedural safeguards are in place, they help to further guard against other related issues that also contribute to faulty convictions, such as such as misconduct by law enforcement personnel, false informant, also known as snitch testimony, and false confessions. I'd like to leave you with this thought. In the case of Mr. Lochner, the crime was very clearly committed by him. He took 6 lives that day, one of which was a federal court chief judge, John Roll, a congressional staffer, the first to be killed in the line of duty, named Gabe Zimmerman, and a 9-year-old girl named Christina Taylor Green, not to mention endangering the lives of dozens of others. Yet, Mr. Lochner was not sentenced to death. In a system that values innocent until proven guilty and equality before the law, it does not seem just to tolerate wrongful convictions, period, especially those that end with the death penalty. Thank you.